SJC-13646, Gregory Rafterty versus State Board of Retirement.
Okay, Attorney Kiley.
May it please the court, thank you for having me here on this petition for certiorari. I'm joined today by John Cubitas. The timing of this case, in many respects, is going to reflect much of what I want to say to you today. I'm here on a petition for certiorari arising out of a decision by the district court in Dedham, in which the judge the judge decided under a heading that is captioned cruel and unusual punishment, and focusing on the federal Constitution, decided that the cruel or unusual provisions of the state Constitution were not in play. We are here in a period of time when federal constitutional rules are forced upon the state and enforced by the judges of the courts. We're here in this court on the basis of a reservation and report by the single justice, which invited a decision of participation in consideration of what our state Constitution means, the independent provisions of the state Constitution. Time passes. Many judges from this court, many Supreme Court of the United States justices have written articles about the importance of a system in which we give
Counsel, can I interrupt you?
Of course.
So why should we interpret our state constitutional clause that says that no magistrate shall inflict cruel or unusual punishments to cover anything other than the duration or conditions of confinement?
Our state Constitution contains no suggestion whatsoever that it is confined to the precedents which deal with conditions of imprisonment. But let me step back. May I step back to
looking at the words of Article 26 itself, it talks about a magistrate inflicting cruel or unusual punishments. And then it also talks about a magistrate imposing excessive fines. And it seems to me your challenge falls squarely within the question whether forfeiting the entire pension was an imposition of an excessive fine, as opposed to an infliction of cruel or unusual punishment.
So, let me state that the brief that I provided you is an unusual brief for me in that it relies primarily on historic facts, the circumstances under which the state Constitution was adopted, the text and history of the provision.
Well, I'm glad you mentioned the history, because I'm wondering if, and you're more familiar with it, having written the brief and researched the history than I certainly am at this point. Is there anything in the history of the adoption of Article 26 and or its implementation since its adoption that would suggest that a pension forfeiture is an infliction of cruel or unusual punishment? Or is this an expansion that you're asking for?
To answer the question very directly, pensions as a matter of property were not a function of the times. if I focus on Betancourt and the opinion that was written there, the reality is that the pension law, the state retirement law, came into being centuries later.
So what's your closest analogy historically then to a pension foreclosure that the infliction of cruel or unusual punishment clause was meant to address?
Any form of punishment whatsoever. And when I refer to the Betancourt decision, it is because there, this court decided that the forfeiture of a pension was punishment. That's the phrase. It's in Part 1B of the decision in Betancourt. A deprivation of property is a punishment.
But doesn't all that history that you bring up in the sort of common historical origins point to this being an excessive fine case, not a cruel or unusual punishment case? And I get we may, we've never interpreted our excessive fine provision, or at least we haven't done it carefully yet, and we can interpret it independently. Why shouldn't, but we also can be persuaded by the U.S. Supreme Court's approach to the same problem. And why isn't what they did here on excessive fines a good model? Because it looks at whether the fine is excessive or, in your words, grossly disproportionate.
Our state constitution, Article 26, contains multiple provisions. They're not mutually exclusive.
I know, but again, I thought you did a very nice job on the history, and so did one of the amicus, but it points to this being most appropriately dealt with under the excessive fine provision. And the Supreme Court, again, a common historical provision about the same time. Again, we're not bound by it, but it's a very thoughtful exploration of what an excessive or disproportionate fine is. So why should we do something materially different? I understand we have to independently analyze it, but why do something materially different?
Well, let me address the United States Supreme Court's very first effort to interpret the excessive fines provision. It's Badger-Cajun. The opinion itself intones that it is the first time that the court has ever had to, or has ever
I read them,
applied
and they're
excessive
very thoughtful explorations of the history, going back to Magna Carta and the, Bill of Rights, the English Bill of Rights, and they're saying this is meant to deal with these excessive fines the king imposed on nobles back in those days, and this is an analogous situation.
A fine is an extraction of money imposed under the federal Constitution by a judge. A forfeiture, and Badger-Cajun is the first time we're dealing with a forfeiture, is a different animal. It has monetary consequences.
Well, how is it different? Because, again, the historical work you did,
So
they're forfeiting their property, it's a fine and a forfeiture are not materially different, are they?
Well, Badger-Cajun equates the two and looks to the opinion of Badger-Cajun looks to the states and the federal decisions dealing with cruel or unusual punishments for its guidance in determining what an excessive fine is. In the brief that I submitted to you, yes, I did an unusual amount of history. It's because it matters.
Could we just, if we go back to our view of what we did here, one of the things that I'm confused about is that in the Betancourt case, which arguably had, we know that the monetary amount was, depending on if you take Betancourt's view, almost $2 million. There wasn't any financial gain to Betancourt, and we said that, right? And that was in the record. But the forfeiture amount, comparably, was greater than it is in this case, because there was no financial gain to Betancourt, and what he was going to completely forfeit, if you use his number, was almost $2 million. And under those factual circumstances, we looked at this and said it was properly looked at as to, first, it was a fine, but the proper analysis was whether the fine was excessive. Now, if we didn't in that case look at it under the cruel and unusual component.
Can I say cruel or unusual?
Cruel or unusual, I know it's and in the United States Constitution, but cruel or unusual, why would we change the analysis to what you're saying? It was arguably, apples to apples, a greater loss to Mr. Betancourt because he had no financial gain, more money that arguably he would lose. And we looked at it and said it's a fine, and the proper framework is the factors under Betancourt as to the proportionality, and that was the proper framework. And now you're saying, less than a decade later, we should now add this other vertical. Why?
In Betancourt, only an Eighth Amendment argument was made. The matter that is here because the judge did not apply the provisions of the state constitution.
Well, he applied them, he just said that they're the same.
He held that the cruel and unusual, or cruel, under the heading of cruel and unusual, he decided that the cruel or unusual provisions were inapposite and just applied the provisions, the constitutional provisions that emanate from the federal government.
Mr. Kelly, can I ask you, assume we agree with you for a moment that Article 26 is different in kind. We've done it in Dychenko and Mattis, of course, and provided more rights than the Eighth Amendment under Article 26. Why should we, in this area, provide greater protections under the state constitution?
Because the state constitution guarantees to the people of the Commonwealth rights beyond those that are bestowed federally.
But when you line them up, sometimes we do, sometimes we don't. Why in this case?
In Dychenko and in the federal and in the Mattis case, there is a focus on the individual, not just the law. The punishment must fit both the offense and the offender. And here, there is no theoretical basis to say that the provisions of Article 26 should be considered differently in the context of a imposition of a sentence and in terms of the imposition of the punishment. There is a punishment that the citizens of I always say citizens, the people of the Commonwealth are guaranteed these liberties. The Constitution was drafted in the heat of the Revolutionary War. We were throwing off all of those old bromides, if you will, and it guarantees to the people of the Commonwealth that there will be no cruel or unusual punishments.
What work, in your estimation, does the excessive fines clause in Article 26 do if you're correct that the cruel or unusual punishments clause covers this fine?
Well, this forfeiture, if you decide that this is a fine, what I would suggest to you is that a judge has considered, it's the U.S. District Court judge, the judge has considered the application of a fine and decided that no fine was appropriate.
What is
My-
the difference between the fine and forfeiture that you seem to be suggesting in your answer to my question?
One carries forward for life, as in this instance. This citizen is deprived of a benefit that he has earned prospectively forever.
Is that because of the nature of the pension being
Pen-
over time?
The pension carries forward throughout your life, right?
Chief, may I ask a question?
Just
Sorry.
want to make sure that we're done with this.
Am I over already?
I have two questions for you, if I may.
For everybody's.
Okay, my first question has to do with the distinction between collateral consequences and a direct consequence from a conviction. So my first question is, as I understand this, the forfeiture of the pension is essentially a collateral consequence, in this case, of his criminal conviction. Have we ever, either on the state or federal side, treated a collateral consequence as a punishment under either the Eighth Amendment or Article 26? And if so, can you please give me an example?
Think for a minute. I can't come up with a case.
Okay, so then the second
I'd like
question.
the opportunity to submit something afterwards. There are cases I can't come up with it.
And the second question is, assume that we were to treat this forfeiture, the collateral consequence, as a punishment for purposes of Article 26. Wouldn't it still be subject, in order to determine whether it was cruel or unusual, wouldn't it still be subject to the rule about proportionality?
You would not, I think you would not be required to apply a gross disproportionality standard as has been applied to the provisions dealing with excessive fines.
And
Excessive, may I?
Sure.
Excessive connotes a comparison in determining what's, and again, Badger Cajun was the first time the Supreme Court had dealt with it, the excessive fines provision. The standard that evolved there in this, in the last century, focuses specifically on proportionality. Cruel or unusual does not focus in the same way on proportionality, and it does not incorporate gross disproportionality. In the McLean case, which is in all of the briefs, which is among the earliest cases that this court has considered under forfeiture, there was a rough equivalence, not the dramatic difference that we've talked about earlier.
Can I ask on that question specifics? So he gets his contributions back, right? So he's going to get whatever he put into the system back. When you did the math on what the loss is, did you subtract that amount or not?
In the brief,
Yes.
yes, I did in the brief.
Okay. So secondly, he's convicted of the same crimes, right, as, was it Finneran? I can't remember. He's got potential 250,000, a number of years in jail, much more than Betancourt, right?
Yes.
And-
Well, there are, I don't know if that's Finneran either, but yes, there are certainly those cases like that.
Right, and also, unlike Betancourt, it's not a momentary lapse. He's engaged in a scheme of embezzling, including covering it up. I have trouble seeing why this is excessive, given that it's not an isolated act. The penalties are quite severe, and a pension is, a defined contribution pension is a big deal, right? It's a privilege for public service, right?
I wouldn't call it a privilege.
Right. Well, it's
I would call it a property right.
okay. But
but-
it's a property right that's really very dramatic because you've served for a long time in state government honorably, right?
Yes.
Okay.
So, I am here to argue that the whole provisions of Article 26, all of them, apply and should be applied to the determination of the application of statute to Mr. Rafterty. They were not applied to him in the district court. I believe they should be applied there. They should be applied in a single justice situation. I think certiorari relief that is warranted is a remand to consider the constitutional claim that was advanced that deals with the cruel or unusual provisions of the Constitution for the reasons that I've articulated in the brief.
Thank you very much.
Thank you.
Okay, Attorney Fahey.
Good morning, Your Honors. May it please the Court, Catherine Fahey, Assistant Attorney General, appearing on behalf of the State Board of Retirement. We're asking this Court today to affirm the District Court's decision concluding that Trooper Rafterty's forfeiture is not unconstitutionally excessive under either Article 26 of the Declaration of Rights or the Eighth Amendment. Under the factors set forth in this Court's decision in P-Rack v. Betancourt, Trooper Rafterty's forfeiture is not grossly disproportional to the gravity of the offense, the underlying offense. As to the first factor under Betancourt, the nature of the offense, there is no question that the triggering conviction is
Before we
serious.
start applying Betancourt, because I don't, so we do have to take a second look, right? This is the first time we've interpreted state constitutional provision. We're not a lockstep state. We don't just adopt the feds, right? So isn't the first part of our analysis, is the Supreme Court's test applied in an analogous provision the right test for us under the state constitution, right? We have to make that call first before we start applying it, right?
Yes, Your Honor, I would agree.
Tell us why should we be persuaded to apply the federal test to the state constitutional provision?
Well, Your Honor, I believe Betancourt achieves the right result here, and additionally, Article 26 should be construed.
But it's the methodology, not the result.
Yes, Your Honor. So where Article 26's wording is identical to the Eighth Amendment, right, it's just a different sequencing of the exact same words. The test under Bajikajian that this court adopted in Betancourt already achieves the aims of proportionality that are at the heart of Article 26. And where Trooper Rafterty has put forth no case law, historical context, or other support that persuasively supports a more expansive interpretation, this court should decline to adopt a more expansive interpretation of than that this court announced in Betancourt.
So your argument is essentially it's the same words, so we should apply the same analysis?
Not exclusively that, Your Honor. It is the same words,
Yes.
but where this court has departed,
They're not the same words.
it is the same words in a different sequence. Apologies, Your Honor.
There's an and versus an or.
As to the excessive fines clause,
No, as
yeah.
to the cruel and unusual.
Yeah, absolutely. There is an and versus an or in the cruel or unusual punishments clause. Our interpretation based on this court's case law is that the cruel or unusual punishments clause is entirely confined to durations or conditions of confinement, and so the or is not relevant.
Where do we find, what do we cite for that? So if we're writing this and we say, okay, we only look under the state constitution to the excessive fees clause, what do we cite for that? Again, we can't just cite Betancourt because Betancourt's interpreting the federal constitution.
Certainly, Your Honor. I think you could look to this court's recent decisions in Madison Diachenko, which recognize that where this court has departed there were numerous supporting circumstances, and in both of those cases, it was limited only to the durations of or conditions of confinement.
But that's just exemplary. It doesn't really say only to the duration and conditions of confinement. Those were the subject matter of those cases. What's your argument that our Article 26 should only be applied to conditions and duration of confinement, other than those just happen to be the most recent examples?
I should take a step back, Your Honor. I don't think you need to go so far as to say it should only be applied to durations or conditions of confinement. It should not be applied here to pension forfeiture, where there is no support for it to be so applied, right? So if you were to write the inverse
Is that because
position,
you've looked, or you're putting the burden on the plaintiff?
my understanding is that his burden to demonstrate excessiveness or cruel or unusual punishment, it is
The
on True
application itself?
The application, and I believe some support for the test that this court is being asked to adopt.
That's a question of law, though, right? Whether a pension forfeiture is an excessive fee is a question of law. A fine is a question of law. Whether it's excessive may be a question of fact and law.
Yes, Your Honor.
I have a question about the facts. And this is, you may assume for purposes of my question that the forfeiture falls under the excessive fine clause. As I understand the facts, the plaintiff had already made his pension election and had retired before he was charged with the crimes. Is that correct?
Yes, Your Honor.
All right. So, and then under his election, he had chosen something called option C.
Yes, Your Honor.
So at that point, his wife had I guess contingent, because it was contingent upon his death, but some kind of vested interest, because once he made that election, am I correct that the election can no longer be changed?
I don't know all the intricacies of option C, Your Honor.
All right, so I think those would be important, because here's my concern. If it is true that that election it cannot be changed after you've retired, then the wife has some sort of interest, some sort of vested interest as of the moment of the election and the retirement. And I'm wondering whether a third party, an adverse financial effect on a third party, has ever been held to be okay under the excessive fines clauses, either under the federal constitution or our state constitution.
So, Your Honor, I don't have an answer for you on that because neither party asserted that, and we did not brief it below. Certainly, if you'd like it to be addressed, I would like to request to submit supplemental briefing on that issue.
It's never been raised anywhere in the down below or here. Right?
I'm aware of a district court case where the issue has been raised.
I'm talking about in this case, this was never raised.
No, not that I'm aware of. It may have been at the board, and I just have not gone back to the record there, but it was not.
Well, the fact of the election is in the record here, correct?
Correct. Yes, and there's no dispute. It was an option C election. If there are no questions on that issue, I'd like to get back to just quickly going through the Betancourt factors, which again we do think are the most appropriate to be applied here as well under Article 26. So as to the first factor, the nature of the offense under Betancourt, there really is no question that the triggering conviction here
I'm sorry,
was a serious
before
one.
you go back to the Betancourt
Sure, Justice
factors, because I understand what they are and how they've been applied. I think the briefing on both sides has been great, as has been the lower court decision. But I guess back to Justice Kafker's point, why should those factors apply to our Article 26 excessive fines clause or to the cruel or unusual punishments clause?
Well, I think I would start by saying that We don't agree that the cruel or unusual punishments clause is applicable here.
Well, I know you don't agree, and my question was not what your position was, because I understood it from the briefing. My question was why the Betancourt factors are the right factors for either the excessive fines clause in our Article 26 or the cruel or unusual punishment clause.
Absolutely, Your Honor. As I mentioned earlier, Betancourt does achieve the aims of proportionality that are at the heart of Article 26. They do consider whether the gravity of the offense is not grossly disproportionate from the forfeiture at issue, and those factors, we believe, are the most appropriate, particularly where there is no...
And so you equate grossly disproportionate from the United States Supreme Court decision to our proportionality to standard for cruel or unusual? And you're suggesting that that would also govern the excessive fines clause?
I am suggesting that that would also govern, and that the standard that this court has adopted under the cruel or unusual punishment, which I do not understand to be dramatically different from the one the Supreme Court adopts, it's applied in a different way by this court. I would suggest that those two standards remain apart for the purposes of pension forfeiture, and in this case. The other reason that I would suggest that the Betancourt factors under Article 26 are appropriate here is that in addition to no authority for a more expansive construction, other factors would not be of a benefit to Trooper Rafterty in this case. So for instance...
Can I ask before you do that, because I think the application's not as complicated as, is the test the right test for us at least?
Certainly, Your Honor.
The district court judge makes the point that it's kind of an all or nothing proposition. Does the Betancourt factors deal with that kind of point? And should a state constitutional test at least address this point? Was that clear? I'm not sure I asked it very clearly, but
I think I understood, Your Honor. You're asking whether the state constitution should deal with sort of the...
Well, does the Betancourt test, which you want us to apply to the state constitution, deal with the concern that the district court judge raised, which is that this has an all or nothing quality to it, so it's roughly proportional as opposed to carefully proportioned or whatever? Mm-hmm.
Yes, Your Honor, I understand your question. So I would acknowledge that our state's pension forfeiture statute is an all-or-nothing statute. This court recognized that it is, for lack of a better word, a blunt instrument in Betancourt, but that is the policy that our state legislature has decided to adopt and has declined to change in light of Betancourt. As far as the factors themselves, they do not account necessarily for that result, because they are intended to get to whether something is grossly disproportionate, right? It's not the fine calibration that might occur in a sentencing exercise, because it is a different inquiry.
Is grossly disproportional the same as excessive? I mean, the Supreme Court said grossly disproportional, I guess, is the right way of analyzing an excessive fine. And you say we should do the same thing, I take it?
Yes, Your Honor. Yes.
Would the remedy for a violation, if we find it's grossly disproportional, but not so much that we could say that Article 26 requires us to take another look at the all-or-nothing proposition and to empower the trial court to do what Judge Byrne wanted to do in this case and not make it all or nothing?
Yes, Justice Gaziano, although we do think that the forfeiture here is completely consistent with the state constitution, as this court recognized in Betancourt, you do have the inherent authority to craft a remedy if you think that something less than an all or a nothing result is appropriate.
Even when the legislature has said all or nothing?
I leave it to this court to interpret as to how they interpret the legislature's decision not to act after Betancourt. You know, there was a commission convened.
You don't think there'd be some Article 30 problems with us saying, well, $1 million too much, you know, maybe $150,000?
I can't say, Your Honor. I haven't considered the issue. I would be happy to consider it if that's a question the court would like me to address.
But can't we look at the all or nothing in this context? Is an all or nothing rule as applied here not excessive? I take it we can do that without running into, you know, ruling the statute is there may be an application of all or nothing. Betancourt was a good example. Okay, the court found that that was excessive under the federal constitution. It might, that all or nothing kind of approach under the state constitution may be unconstitutional. And we may draw a different balance too of when that occurs, right?
Yes, Your Honor. So in addition to having the inherent authority to craft some sort of remedy in this case, although you've declined to do so, courts generally try to narrowly circumscribe.
But we did. In Betancourt, we said it failed to meet the federal the all or nothing remedy in Betancourt was failed the federal constitution.
Correct.
And here we could draw, again, we can balance rights differently under the state than the feds. But we do have to come to terms with the fact the state has imposed an all or nothing, and sometimes that may be too much, right?
Yes, Your Honor, and as you point out, it is possible to adopt a test that in the circumstances where and in fact, Betancourt did adopt a test that in the circumstances where a forfeiture is excessive, it cannot be imposed.
In assessing whether a particular forfeiture is grossly disproportionate, should we take into account the particular circumstances of the person involved and particularly whether they are presently destitute?
So,
which I recognize is not argued here.
Yes, Your Honor. So as you know, that is not argued here, but I would point out that that is outside of the inquiry that this court recognized in Betancourt, right, which is whether the forfeiture is grossly disproportionate.
Well, that was under the Eighth Amendment, but I'm asking about Article 26.
Yes, absolutely. Yeah, so our position is that under Article 26, because the Betancourt test should also be adopted, the question of the individual's personal financial circumstances should be outside of the test.
Is the Betancourt test, are those factors exclusively the ones that can be measured under the Eighth Amendment, or are those including but not limited to factors?
Your Honor, it's exclusive to the 4 factors.
Thank you.
But we could create a state constitutional test that supplements that, right? There's nothing that would preclude us from doing that if we felt that that was not as good a constitutional test as can be devised under the state constitution, right? We can supplement that.
Yes, Your Honor, this court has the power to supplement. Certainly, it's the board's position that you should decline to do so here, but you are free to do so.
And I'm correct, am I, that the issue is whether the amount of the forfeiture is grossly disproportionate to the gravity of the offense, and the Betancourt factors only go to the gravity of the offense. We still have to weigh the proportionality, correct? It's the factors, to Justice Wegman's question, the factors only go to gravity of offense, correct?
Yes, Your Honor. But my understanding is that because the excessive fine is being imposed as a payment as punishment for some offense, in addition to other reasons under the pension forfeiture statute, the focus of the inquiry is the proportionality of the forfeiture to the gravity of the offense, and not factors outside of that.
But in every Article 26, Eighth Amendment, it's always the touchstone, as we say, is proportionality.
Yes, Your Honor. If there are no further questions, I see I'm over time, so I will rest on my papers.
May I bring a citation to the attention of Judge?
Thank you.
Let's do a 16L letter.
Letter?
Okay.
Thank you.